Hi everyone, my name's Anthony Turner. I'm an accredited multiple choice question writer, retired inspector and former head of continuation training in Hampshire. Now the purpose of this presentation is to explain how the NPPF Step 2 legal examination works and along the way provide you with lots of information designed to help you achieve success. Okay, so first up then we're going to look at the importance of currency when preparing for the exam. Then we'll look at the structure of the exam itself, the devil in the detail of the multiple choice questions, how they're prepared and put together, some key principles linked to the same thing, and a list of study aids that I have available for you in preparing for the exam. And this includes my police promotion handbooks, which cover each of the three areas covered within the exam: crime, GPD, and evidence and procedure. And my YouTube channel, which offers you 700 plus free lead-in and 2 option questions. Okay then, so let's take a look at all of those things in some more detail. Now, as I'm sure you'll be aware, the National Police Promotion Framework Step 2 legal examination adopts a multiple choice question format, the source for which comes entirely from the current online or hard copy editions of the Blackstone's police manuals. So while there might be a temptation to perhaps buy older sets from a colleague, personally I wouldn't, on the basis that with questions derived exclusively from legislation, case law and keynotes, the importance of being up to date in all such areas is therefore self-evident. For example, in case law, R.V. Ghosh 1982 once featured heavily when dealing with the issue of dishonesty under the Theft Act. At least that was the case until Ivey versus Genting Casinos in 2018 and Barton and Booth versus R in 2020, when the Supreme Court clarified the provisions of law, consent and reasonable steps. However, and for the purposes of the exam, further clarification now states that this test will be considered objectively in accordance with civil cases set out in Barlow Close International versus Eurotrust International Limited 2006 and Royal Brunei Airlines versus Tan 1995. Now, in terms of the multiple choice questions themselves, you'll be facing 150 questions in 3 hours, which roughly equates to 72 seconds a question. Now, while this may sound a lot of time, trust me, it isn't, especially if you spend too much time thinking about one question or indeed fretting over another while trying to focus on the next. So, if you can learn to deal with this type of head blocker and move quickly on, then please do so, and you'll avoid wasting valuable time. Each question will in turn be made up of between 55 and 250 words, the purpose being to provide a 50-50 split between reading and deciding the correct answer. Okay, now of those 150 multiple choice questions, 10 which have performed least well in the exam will be removed, thus ensuring candidates, you, are not unfairly penalised. In turn, the pass mark is set at 55% for sergeants, so that's 77 questions out of 140, and 65% for the inspectors, so 91 out of 140. Right, well, further information on these subjects can be found online at the College of Policing website, which I urge you to study carefully to ensure you have a full appreciation and understanding of what is required. Okay, now let's take a moment to look at the devil in the detail as to the formatting issues surrounding these questions. Referred to as A-type questions, they consist of a stem, which includes a case study, scenario, or vignette. That's a posh word for setting the scene. A lead-in, which specifies the question to which you're asked to provide an answer. And of course 4 options, of which one is obviously correct, while the other 3 are what they call plausible distractors. Okay, so let's have a look at an example. Here we have the stem. Detective Constable Gotten wishes to carry out non-urgent director surveillance on a commercial car repair garage belonging to Lewis. It is suspected that Lewis is operating a car ringing enterprise at the garage, and DC Gotten wishes to obtain intelligence about the operation. So there is your scenario, if you like. And then we have the lead-in. So what exactly are they looking for in relation to an answer from you? In accordance with Chapter 3 of the Covert Surveillance and Property Interference Revised Code of Practice for 2018, who can authorise this surveillance and for how long? And finally, the options that you have available to you. So, is it A, an officer of the rank of inspector or above may authorise this surveillance for a period of up to 3 months? Or is it B, an officer of the rank of inspector or above may authorise this surveillance for a period up to 6 months? Or is it C, an officer of the rank of superintendent or above may authorise this surveillance for a period of 3 months? Or D, an officer, again of the rank of superintendent or above, may authorise this surveillance for a period of 6 months. Now, in this instance, knowing that authorization for a pre-planned directed surveillance operation rests with a superintendent or above, then immediately this draws your attention to option C or D. And then, of course, if you've done your homework, you'll know that the correct answer is C. And it's that potential conundrum that's the premise for familiarising yourselves with some of those key principles associated with multiple choice question writing and, if necessary, taking advantage of any one or indeed a number of those additional external study aids that are out there in the marketplace. So let's take a look at some of those key principles adopted by multiple choice question writers. After all, if you have a basic understanding of where these questions are coming from, this should help you to maximize your time available for each question. Okay, first up then, read the question. Now that sounds obvious, but you may be surprised at how many candidates think they know what the question is about and skip over important information in the stem and choose a credible yet incorrect option. Okay, so here's an example. While on patrol in the High Street at 3 a.m, Police Constables Gillard and Kimber approach 3 youths who are in possession of unlit petrol bombs. The youths scatter and throw the bombs away before they are detained and arrested by the officers for the offence of affray. Now, in accordance with Section 3 of the Public Order Act 1986, affray, have the officers acted correctly under these circumstances? So, what have we got? Is it answer A? Yes, as the conduct of the youths would cause a person of reasonable firmness present to fear for his or her personal safety? Or is it B? Yes, as mere possession of the petrol bombs would constitute a threat for the purpose of this offence? Or is it C? No, for this offence to be complete, the conduct of the youths must be directed towards property? Or is it D? No, for this offence to be complete, the conduct of the youths must be directed towards the person present at the scene. Well, the answer to this question, which you've read carefully, combines the definition of affray with case law. First up then, the definition. A person is guilty of affray if he uses or threatens unlawful violence towards another, and his conduct is such as would cause a person of reasonable firmness present at the scene to fear for his personal safety. Okay, so from case law's perspective, answer A is incorrect on the basis that while R.V. Sanchez 1996 and R.V. Carey 2006 identifies that a person of reasonable firmness does not have to be present at the scene, I versus DPP of 2001 clarifies that in order to prove the offence of affray, the threat of unlawful violence must be directed towards a person present. So the temptation here is to dive in and say answer A is the correct answer, hence the need to read the question carefully. And answer B is also incorrect, as while possession of the petrol bombs would constitute a threat, the conduct must still be directed towards another. Similarly, answer C is incorrect, as unlawful violence is again restricted by the term towards another and does not include property. And that leaves us with answer D as the correct answer, based on, again, the House of Lords ruling that in order to prove the offence of affray, the threat of unlawful violence must be directed towards a person present. And that again is in relation to I versus DPP 2001. Okay, next up then we have cover up. And what I mean by that is answering the question in your own mind before looking at the four options will save time when reviewing the answers, but only if you're sure of your facts, for example. Now here, just out of sheer devilment, to be perfectly honest, I'm going to go back to the question I identified for you earlier on involving Detective Constable Gotten and see whether or not you've remembered the answer. But essentially the principle is here. If you know what directed surveillance is in the detail, remember the devil in the detail, then you will be able to dive straight into the correct answer. So just to recap then, Detective Constable Gotten wishes to carry out non-urgent directed surveillance on a commercial car repair garage belonging to Lewis. It is suspected that Lewis is operating a car ringing enterprise at the garage, and DC Gotten wishes to obtain intelligence about the operation. So again, in accordance with Chapter 3 of the Covert Surveillance and Property Interference Revised Code of Practice of 2018, who can authorise this surveillance and for how long? So was it A, an officer of the rank of inspector or above may authorise this surveillance for a period up to 3 months? Is it B, again an officer of the rank of inspector or above may authorise this surveillance for a period of 6 months? Is it C, an officer of the rank of superintendent or above may authorise this surveillance for a period up to 3 months? Or is it D, an officer of the rank of superintendent or above may authorise this surveillance for a period of up to 6 months? And I very much hope that you're all going to go for answer C. But you see what I mean? Covering up those answers, in other words, don't look at them, get that answer right in your head, you go straight for C, and you save an awful lot of time. Okay, next up then we've got keywords. Now, recognizing keywords in definitions may also help you focus on the correct answer. However, on occasions they can also be confusing. For example, Eels rents a house under a tenancy agreement from his local council. Eels is short of money and decides to sell off several items from the house to help him through a cash crisis. So, which of the following circumstances is correct when dealing with the offence of theft of land in accordance with Section 4, subsection 2 of the Theft Act 1968? Is it A, Eels picks flowers from the front garden to sell at a car boot sale and commits the offence of theft of land? Is it B, Eels severs some topsoil from the garden to sell to his neighbour and may commit the offence of theft of land? Is it C, removes a fireplace to sell at a nearby second-hand shop and may commit the offence of theft of land? Or is it D, Eels cannot commit the offence of theft of land while under a tenancy agreement? Okay, so once you've focused on the tenancy element in the stem of the question, and then the removal of the fireplace in the options, you'll know that when we're talking about theft of land, that C is your correct answer. Okay, next up then is to focus our attention on the lead-in element of the question. And if we read this first, then we know, in some instances, what is required from the stem. And then this allows us to, if you like, read the stem from a more informed perspective in readiness for looking at the options. Okay, so for example, the lead-in in this question is this an offence of blackmail contrary to Section 21 of the Theft Act 1968? So now let's look at the stem and see if we can formulate in our own minds whether or not we are looking at offence of blackmail here or indeed something else. Gilchrist has just started a new job at a bank when she is approached by Baxter, who tells her that he knows she used to be a prostitute and that if she does not have sexual intercourse with his friend, Humphreys, he will inform the bank manager and she will probably be sacked. Gilchrist reluctantly agrees to Baxter's demand and has sexual intercourse with Humphreys. Okay, so now we know specifically what the question is asking. In other words, is this an offence of blackmail? We've looked through the stem and we've able to hopefully make a decision as to whether the answer to that is yes or no. So within the options, you have 2 yeses and 2 nos. Let's have a look at what they are and then see if we can get the correct answer. So, is it answer A? Yes, because Baxter makes the unwarranted demand with a view to gain a benefit for another. Is it B? No, because gain for the purposes of this offence extends only to the obtaining of money or other property. Is it C? Yes, because gain for the purpose of this offence relates to anything, including sexual gratification. Or is it D? No, because Baxter did not make the demand with a view to gain for himself. And of course the answer is B. No, because gain for the purpose of this offence extends only to the obtaining of money or other property. However, be warned, although this is a very useful technique, it's not always the case that this will work, as you'll see from the next example. So here we go then with the lead-in. Which of the following statements is correct with regard to Turvey? Well, that's not specific in the same way as the previous question, is it? So what we have to do now is we have to bear that in mind, that the following options are going to, one of them is going to be correct, obviously, but that's all linked to the information that you'll find within the stem. So what have we got then? Turvey has just lost his job and is finding money hard to come by. Randall feels sorry for him and gives Turvey a packet of 10 cigarettes that also contains a small amount of cocaine. Turvey knows nothing about the cocaine inside the packet of cigarettes. Several hours later, Turvey is stopped by Police Constable Mayer, who discovers the cocaine inside the cigarette packet. So now you have all of that information. Now you need to determine which of the following statements is correct with regards to Turvey. So is it answer A? As Turvey has physical control of the cigarettes and knows of their presence, he also has possession of the drug. Or is it B? The only requirement for possession is that Turvey had the drug in his physical control. Or is it C? To show that Turvey has possession of the drug, you must show that he actually knew what he possessed was cocaine. Or is it D? Turvey cannot be in possession of the cocaine because he doesn't know of its existence. And the answer is A. As Turvey has both physical control of the cigarettes and knows of their presence, and that's the cigarettes we're talking about here, he also has possession of the drug. Now that doesn't mean that he's necessarily going to get prosecuted, because there is the statutory defence of not knowing that you were in possession of the drug. That's fine. But the reality of the situation in terms of what the meaning of possession in this case is exactly that. He has physical control of the cigarettes and knows of their presence. And finally, we have elimination. Now, even though you may not be 100% sure of the answer, eliminating those clearly incorrect options can still achieve a positive result. For example, Constable Jenkins is seeking an inspector's authority in relation to searching a bedsit, which he suspects is occupied by Grant, who is in custody on suspicion of burglary, an indictable offence. Now, in respect of these circumstances, is the inspector able to authorise the search of Grant's bedsit? So is it answer A? Yes, the search may be authorised as it is suspected that Grant occupies or controls the bedsit. Or is it B? Yes, as Grant is in custody on suspicion of having committed an indictable offence, the request may be authorised. Or is it C? No, the search may not be authorised unless it is believed that Grant occupies or controls the bedsit. Or is it D? No, the search may not be authorised unless Grant actually occupies or controls the bedsit. Okay then, knowing the definition of Section 18 of PACE will tell you that mere suspicion on the part of Constable Jenkins as to Grant's occupancy of the bedsit is incorrect, which immediately eliminates answers A and B. Okay, so that leaves you with the two options of C and D, which are both no options. And in this particular case, the answer is D. And the reason for that is that it is a factual requirement that the premises is or are occupied or controlled. Therefore, an officer's suspicion or belief is insufficient. Now, in terms of materials designed to help you achieve success in the exam, there are a host of study aids out there in the marketplace. And before you commit to one or more, I suggest you take a look at them all to see which suit your individual style of learning. Now, with regards to what I can offer, well, this, as previously mentioned, includes a series of police promotion handbooks, each of which are individually priced, so you can either pick and choose as you feel necessary rather than having to buy all three. Now, included in the handbooks, you'll find an easily digestible format of flowcharts, case law, and questions, all of which are designed to focus on those key areas of learning that regularly appear in the exam. I've also included a 21-week study program which, when coupled with the relevant subject area breakdown data derived from recent exams, we'll come to that next, this allows you to study from an informed perspective rather than simply taking pot luck as to what is likely to come up in the exam. Week 16, for example, looks at crime and theft and related offences, which for both the sergeant and inspector exams have averaged in excess of 5 multiple choice questions per exam in recent years. And, as you can see, going equipped features perhaps more highly than you might expect. It is important to note, however, that questions for the NPPF Step 2 legal examinations can be derived literally from anywhere within the Blackstone's police manuals. Therefore, this statistical analysis of recent exams should not be relied upon to determine future trends. And finally, so far as the handbooks are concerned, I also offer a wide range of fully debriefed A-style multiple choice questions to assist in your revision. This is in addition to the short, sharp, punchy type questions that you'll encounter throughout each of the 3 books. Okay, so if this style of learning suits your individual needs and you'd like to purchase the handbooks, then please go to amazon.co.uk, where you can use the drop-down menu to highlight books, then type in and search the ISBN, or International Standard Book Number, shown on the screen for each of the individual handbooks. That will take you to the relevant page and you can go from there. Okay, so with regard to these 700 plus free questions that you can access on my YouTube channel, these are broken down into 28 modules featuring what I call lead-in and 2-option questions. The idea being to cater for those head-scratching moments when you're down to those final 2 options and not sure which one to go for. For example, where a person is caught shoplifting and the collective value of the goods stolen is £275, in accordance with Section 22A of the Magistrates Court Act 1980, which of the following statements is correct? Is it A, this figure represents a low-value shoplifting and will be tried summarily? Or is it B, this figure is not regarded as a low-value shoplifting and may be tried either way? And of course the answer is B. The threshold for a low-value shoplifting is £200 and will be heard summarily unless, and this is the key here, you may have a question that looks fairly straightforward, but then they throw in something like that the alleged offender is over 18 years of age and elects Crown Court trial. Well, that's not the case in this instance, and the collective value of goods stolen is £275 and therefore may be tried either way. So every now and again I'll throw in a little bit of extra information that just gets the cogs whirring and tests the depth of knowledge for you when you're studying. Okay, so if you'd like to take advantage of the free questions, then all you need to do is go to my YouTube channel by putting into the search engine at anthonyturner.nppf-nie, and that will take you to my channel. The only thing I have found in the past for some people is that they get a bit confused then as to how to access the individual modules. So let's take a look at the next slide and hopefully that will help. Okay, so to find the channel then, as mentioned, type at anthonyturner.nppf-nie into the search bar, click search, and then click on my image, and follow this by clicking on the videos section, and all will be revealed. Okay, well, that's it. I hope you found the presentation useful, and hopefully the handbooks and YouTube channel, if you decide to go down that route. And Good luck with your studies, and I hope you're successful in getting through the exam.